Welcome back to the Anti-Federalist Project. I'm your host, Jacob Solt, and I am producing a series of videos on the Anti-Federalists and what I feel is their latent ideology as part of the publication and dissemination portion of my graduate thesis. In this video, I want to take a look at one of the ideological assumptions I feel is latent within the ideology of most of the Anti-Federalists, and that is the assumption of an ethical natural rights theory, and how the Anti-Federalists would integrate that theory into their ideas on politics. And I think this is important for understanding the disagreement between the Anti-Federalists and the Federalists. By this, I do not mean to imply that there is one particular integration of natural rights theory that all of the Anti-Federalists hold. As I've discussed in my research, the Anti-Federalists were highly diverse in their opinion and use of argumentation to express their disapproval of the Constitution as it was conceived in the Constitutional Convention. But I would go so far as to say that in the most well-conceived of Anti-Federalist critiques of the Constitution, in the writings of Brutus, Federal Farmer, Mercy Otis Warren in particular, I see that the theory of natural rights kept popping up in my reading of the Anti-Federalists. And perhaps this was due to my interest in philosophy, or how ideas influence people's actions, but it was a natural avenue for me to explore this theory in some depth in my research. So where does this idea of natural rights come from? Well, the historical traces of the idea are quite old. The primordial basis of the idea of natural rights is that individuals have rights by their very nature as persons. These natural rights are possessed by individuals prior to any other claim, as they are possessed by the individual prior to the individual's entering society, the polity. And therefore, there can be no legitimate violation of those rights, either by other persons, society, community, or political arrangement, at all. And one of the more interesting of the early statements conforming to a natural rights theory that I'm aware of is Bao Xinyan, who wrote, "The Confucian literati say, heaven gave birth to the people and set rulers over them. But how can high heaven have said this in so many words? Is it not rather that interested parties make this their pretext? The fact is that the strong oppressed the weak, and the weak submitted to them. The cunning tricked the innocent, and the innocent served them. It was because there was submission that the relation of lord and subject arose, and because there was servitude that the people, being powerless, could be kept under control. Thus servitude and mastery result from the struggle between the strong and the weak, and the contrast between the cunning and the innocent, and the blue heaven has nothing whatsoever to do with it." Bao Xinyan declares from this introduction that there are neither lords nor subjects. There are just societies where people are equals and treat each other equally, and there are societies where there are systems where people are illegitimately subjected to oppression and violence. There are, of course, many other statements that could apply to natural rights from ancient sources. These would include the ancient Greek Stoics, such as Seneca the Younger, to the Roman Cicero, and a variety of religious texts. But consider the implicit ideological statement within Sophocles' play Antigone. Antigone, here responding to King Creon's charge at having violated Creon's law, forbidding the burial of her brother, Antigone states, "For it was not Zeus that had published me that edict. Not such are the laws set amongst men by the justice who dwells with the gods below. Nor deemed I that thy decrees were of such force that a mortal could override the unwritten and unfailing statutes of heaven. For their life is not of today or yesterday, but from all time, and no man knows when they were first put forth." Antigone claims that not even the king can legitimately make a law that violates the justice residing with the gods or of the unwritten laws of heaven. And as I'd mentioned earlier, that a variety of religious texts contribute to natural rights theory. And before I get into John Locke, I think it's important to point out that unique European dynamic that emerges out of the fall of the Roman Empire, that this interesting feature of European history, such that the seat of religious authority and the seat of political authority are divided. So it's kind of hard to overestimate this particular effect has on natural rights theory, for it allowed many thinkers who objected to the oppression of political rulers by appealing to a higher authority. And whatever you or I might think about religion, it'd be difficult to overstate the importance of this natural rights theory. For if individuals are endowed by their creator with certain unalienable rights, sound familiar? Then how can any political tyrant be justified in violating these rights? But skipping over the great stuff by Cicero, Augustine, Botway, and Sidney, I will fast forward to the premier philosopher of natural rights theory, John Locke. John Locke, in the Second Treatise on Government, would identify the essential natural rights as the familiar life, liberty, and property. Locke's conception of natural rights theory begins in what he calls a state of nature, and it goes as follows. To properly understand political power and trace its origins, we must consider the state that all people are in naturally. That is a state of perfect freedom of acting and disposing of their own possessions and persons as they think fit within the bounds of the law of nature. People in this state do not have to ask permission to act or depend on the will of others to arrange matters on their behalf. The natural state is also one of equality, in which all power and jurisdiction is reciprocal, and no one has more than another. It is evident that all human beings, as creatures belonging to the same species and rank, and born indiscriminately with all the same natural advantages and faculties, are equal amongst themselves. They have not relationship of subordination or subjection, unless God, the Lord and Master of them all, had clearly set one person above another and conferred on him an undoubted right to dominion and sovereignty. So, Locke is stating here that to understand the very nature or essence of people, we must first understand how people are apart from society, that is, how they are in a state of nature. The idea here is that if people have all these rights in a state of nature, which is prior to the individual entering a society, why do not people in a society have this same perfect freedom? Why can they not still do as they please? Well, Locke has something to say about this. For if man in a state of nature be so free as has been said, if he be lord of his own person and possessions, equal to the greatest, and subject to nobody, why will he part with his freedom? Why will he give up this empire and subject himself to the dominion and control of any other power? To which it is obvious to answer that though in the state of nature he hath such a right, yet the enjoyment of it is very uncertain, and constantly exposed to the invasion of others. For if all being kings as much as he, every man his equal, and the greater part no strict observers of equity and justice, the enjoyment of the property he has in the state is very unsafe, very unsecure. This makes him willing to quit a condition which, however free, is full of fears and continual dangers, and it is not without reason that he seeks out and is willing to join in society with others, who are already united or have a mind to unite, for the mutual preservation of their lives, liberties, and estates, which I call by the general name property. So here we have Locke's famous rights, life, liberty, and property, that people in a perfect state of nature, in order to secure their rights from invasions from others, enter into this social arrangement that they feel is best suited for preserving their life, liberty, and property. That is to say, that societies and polities are entered into in order to best secure the rights of the individual. But before you think that these rights are forever surrendered, Locke makes this argument. Whenever legislators endeavor to take away and destroy the property of the people, or reduce them to slavery under arbitrary power, they put themselves into a state of war with the people, who are thereupon absolved from any farther obedience, and are left to the common refuge which God hath provided for all men against force and violence, Whensoever, therefore, the legislative shall transgress this fundamental rule of society, and either by ambition, fear, folly, or corruption, endeavor to grasp themselves or put into the hands of any other absolute power over the lives, liberties, and estates of the people, by this breach of trust, they forfeit the power the people had put into their hands for quite contrary ends, and it devolves to the people who have a right to resume their original liberty. So then this is the implicit ethical principle supporting the right of the people to revolt against an unjust rule, such as the American Revolutionary War. And when the Anti-Federalists argue for the natural rights of individuals, they are keeping to the very spirit of the revolution itself. For if people do not have natural rights, then all injustice can be legitimized, merely because it is the law. But if people do have natural rights, then no law can be just that takes away a person's life, liberty, or property. As St. Augustine would say, an unjust law is no law at all. For the Anti-Federalists, the Constitution represented an unnecessary and potentially harmful proposition, that it would require an additional surrender of rights that had been won during the Revolution. The Anti-Federalist George Mason, who was one of the delegates to the Constitutional Convention, had said during the Virginia Convention of Delegates to ratify the Constitution that all men are by nature equally free and independent, and have certain inherent rights, of which, when they enter into a state of society, they cannot, by any compact, deprive or divest their posterity, namely, the enjoyment of life and liberty, with the means of acquiring and possessing property, and pursuing and obtaining happiness and safety. So, as I said before, I think that this idea of natural rights that led the Anti-Federalists to reject the Constitution and to argue against its ratification. If the Constitution appears to the Anti-Federalists as setting up a government which is given powers that could be abused by tyrants and demagogues, which could conceivably create an oppression of the people, violating their natural rights, then that government would be illegitimate. Well, we're nearing the maximum length for what I am aiming at in these videos, so in the next video I would like to more explicitly describe how this theory of natural rights influences the thoughts of some of the Anti-Federalist writers, and how their particular interpretation and integration of the theory gets them into an ideological conundrum, which is why I titled my thesis Reconciling Contradictions. Well, until next time, this has been Jacob Solt on the Anti-Federalist Project, and thank you for watching.